Welcome to Kikar, Conversations in the Jewish Public Square, a podcast brought to you by the Jewish Leadership Conference. I'm your host, Jonathan Silver. 6 months after the Supreme Court heard Masterpiece Cakeshop v. Colorado Civil Rights Commission, they handed down their ruling. By a vote of 7-2, the court overturned the Colorado Court of Appeals, and another chapter in the ongoing tension between the equal rights of LGBT citizens and America's constitutionally protected religious liberties has come to a close. The main constitutional issue of the case is the claim to equal rights on the part of the couple commissioning the cake, and whether the government should have the power to coerce the baker. The case opens up a lot of issues for us as Americans, and big questions for us in the American Jewish community in particular. Liberal Jewish groups expressed disappointment in the court's ruling, arguing that the government has a responsibility to treat all its citizens equally, and that equality is a Jewish principle that Jews must protect. Orthodox groups were pleased by the court's ruling, which protects sincerely held religious expression from government coercion. To help us make sense of the case, I spoke to Yuval Levin, editor of National Affairs, probably the most important policy journal in the United States. Yuval believes that as more and more Americans accept the idea of same-sex marriage, traditional Jews and Christians will increasingly need to think about their situation as minority believers in a country with an established faith. Not a religion exactly, but faith in secular progressivism. If you like this episode of Kikar, please subscribe on iTunes or Stitcher, or find us on YouTube. And if you're interested in our work at the Jewish Leadership Conference, visit our website, jewishleadershipconference.org, and follow us on Facebook and Twitter. Here now is Yuval Levin. Yuval Levin, welcome to the Kikar.
Thank you very much.
So we're going to discuss Masterpiece Cakeshop versus Colorado Civil Rights Commission, the opinions and judgment that was handed down from the court yesterday. Why don't you just set the scene for us and tell us what the case involved and what the majority opinion was?
Well, the case began with an incident in 2012 in which a gay couple came into the Masterpiece Cakeshop in Colorado and asked the owner and baker, Jack Phillips, to bake a wedding cake for them. They had gotten married outside of the state. Colorado at the time did not have gay marriage yet. And they were going to have a celebration for their friends and family, and they wanted a special wedding cake to celebrate. Whether they knew it or not, Jack Phillips was an Orthodox Christian, and he had a longstanding rule against making cakes for example, for Halloween. He had once been asked to bake a cake for a divorce celebration and had declined. And he applied the same rule now to their request and said he was happy to sell them a cake he had on the shelf or to bake them a birthday cake in the future, but he didn't want to bake a cake to celebrate a gay wedding or marriage. They essentially sued. They brought a case against him with the Colorado Civil Rights Commission under a law the state had to protect people from discrimination on the basis of a variety of things, including sexual orientation, but also including religious beliefs. And so, in a sense, the argument before the Civil Rights Commission was about whether they had a right to expect him to provide them with the kind of service he would have provided to a heterosexual couple and have him bake their wedding cake. Ultimately, the commission decided that he did need to bake the cake, and the case went through the state courts, which affirmed the decision of the commission. And ultimately from there to the Supreme Court, the court handed down its decision, a 7-2 decision, somewhat surprisingly, but at the same time also a very narrow decision, siding with Phillips, with the baker, but on the basis of the Colorado Civil Rights Commission showing what the court described as open animus to his religious beliefs. They quoted some of the commissioners speaking about his religious views as inherently discriminatory, and ultimately decided that the commission had made clear in the course of its deliberations that it did not take his religion seriously and that it had a kind of open animus toward his beliefs. And so the court settled this case, but it's not at all clear that it's resolved the overall question, of which this case is one instance, about whether essentially participating in the now national acceptance of gay marriage is required of religious believers in order for them to be able to participate in the private economy and in the public square. That question remains open, and there will surely be more cases before it gets resolved.
The fact that this is a dispute between the bakery and the Colorado Civil Rights Commission itself, instead of the two gentlemen who brought the case, suggests that there is an element of, well, in the case of the state of Colorado, that the state itself had put its thumb on the scale here. And so often when we think about the First Amendment's protection of religious views, we think about the expression of religious views. But of course, if the state itself had an impartial role in the matter, that suggests that it might not be expression, but the other clause in the First Amendment that usually doesn't command so much of our attention, the Establishment Clause.
Yeah, it's an odd situation, and you could see the lawyers in this case struggling with the peculiar dynamics of that question. They certainly pursued this as a question of the practice of religion and tried to avoid the establishment question. And so the way it was put to the court was really about whether the baker's freedom of religious practice and expression was somehow curtailed by being compelled to act in ways that his religion prohibited. There was also an element of this case that involved First Amendment speech protections. That is, a question of whether baking the cake amounts to a kind of compelled speech. Phillips's lawyers argued that he was an artist, that baking this cake is the way he expresses himself, and that being forced to do it to celebrate something he didn't find cause to celebrate was a kind of compelled artistic expression, and so a violation of his free speech rights. The court completely avoided that issue. A couple of the justices would like to have dealt with it. Justice Thomas wrote a concurring opinion in which he argued that the free speech question is a very important one. Justice Gorsuch joined him in that opinion, but others didn't, and the majority opinion didn't take it up. And they entirely avoided the possibility that there was an establishment question here. The word does not appear in the decision. But if you think about the situation that this baker found himself in, he was essentially being told that there was a view of marriage that was the larger society's view, and that in order to participate in the life of that larger society, to have a role in the economy and be able to run a bake shop, he had to not only abide that view, but actually participate in it, in a kind of rite of it, participate in the celebration of a gay wedding that embodied an idea of marriage that was at odds with his own religious understanding of marriage. And so his situation in some respects is more like that of a member of a religious minority in a society with an established church than like that of a person trying to exercise his religion. And so, if not as a legal issue, and probably not as a legal issue since the religion in question is progressive liberalism, which isn't actually a religion, at least as a conceptual matter, thinking about this through the lens of the Establishment Clause can help us understand the situation that religious traditionalists find themselves in, which in a lot of respects is like the circumstances of a religious minority in a country with an established church. And if a kind of liberal progressivism is now going to be our established civil religion, then the logic and tradition of the Establishment Clause, which is a distinctly American tradition. You know, our tradition of religious toleration comes from Britain, but Britain has an established church and always did. And so the Establishment Clause tradition is decidedly American. It begins with James Madison, and it has a lot to offer us in understanding what's at issue in cases like this.
Were you able to follow the reaction of the Jewish community to yesterday's decision?
Well, I can't say I followed it in detail, but, the reaction was more political than religious and fell into a kind of denominational arrangement that might have been expected. The Orthodox Union had filed an amicus brief on behalf of the baker in this case. At the same time, the conservative and reform synagogues made clear in various ways that they were much more on the side of the couple here and of the Civil Rights Commission, and my sense is that's what the reaction has been like, too.
And of course, the non-orthodox ways of thinking about the question, as you say, perhaps politically motivated as much as, or perhaps more than religiously motivated, but all the same, bring a serious religious argument to the way they think about it. Mm-hmm. The non-orthodox way, the reform and liberal and conservative way of thinking about the question, fastens our attention on the question, on the biblical question of how to treat every man and woman as created in the image and likeness of God. And from that verse derive a kind of epistemological equality, which yields a civil equality. And that civil equality is the job of government to protect. So they see this case as an abrogation of equality, and they see the court as not protecting a religious view, but transgressing a religious view.
Yeah, absolutely. Look, and it's a serious view. It's an approach to the question that has a lot to do with the broader liberal society's understanding of its own moral foundations and moral character. But it has to be understood, too, that this idea of equality that is at the core of the modern liberal society, and that is also a Jewish idea and a Christian idea, is an idea of equality that always has to be channeled through some understanding of a broader set of moral obligations and categories. Marriage has some definition. There are going to be some things that are marriage and some things that are not. And the question of which is not self-evident. It requires us to apply various kinds of categories and rules and principles and traditions. And the question of which these will be is a question that the liberal society tends to answer by saying that different people will approach them differently. And oftentimes, the place of religious toleration in our tradition has been to enable different people to answer fundamental questions like this in a different way, in different ways, but still participate together in one society. And so here, religious toleration really operates as a defensive measure, particularly for minorities, for moral minorities and religious minorities. And I do think Jews in particular should be sensitive to this and should appreciate the importance of preventing the larger society from imposing its own moral vision on minorities, on religious and moral minorities, with the force of the state. And so while we can certainly have an argument about what the right way to understand the idea of marriage ought to be, we also ought to accept that at the end of the day, there will remain still a difference of opinion on this question, a difference rooted in religious views, rooted in religious traditions, and that there ought to be a way for people to have different answers to that fundamental question and still live together in society. Religious freedom is essential to being able to do that, and so it is essential to the freedoms that Jews as Jews enjoy in a society like ours. And we ought to be defensive of it, even when it protects a space that isn't our own space.
This conversation was recorded on June 5th. Yuval Levin, thank you very much.
Thank you.